Welcome to this presentation covering the first half of Chapter 5. The topic of this chapter is mutual assent of the parties. So let's begin. Let's first of all talk a little bit about what we mean by mutual assent. The two words are not probably unfamiliar to you. We know mutual means that both parties are engaged in a particular activity or a particular perspective. So we need to have a commonality. Both of the parties to the contract share this aspect. And assent means agreement, saying yes to something. So in order to have a true agreement, we need to have mutual assent. We need the two parties to say, yes, I mean what he just said, and I mean what she just said in that particular situation. That's kind of a common sense. I mean, how can you have an agreement if the two parties aren't willing to say, yep, I'm on board with what the other person just said? So it's kind of a common sense approach, but we're going to see a few scenarios, 6 to be specific, wherein we can have an issue about whether we truly have mutual assent or not. This is the definition that you're responsible for this class. A mutual assent is the meeting of the minds. It's consent. It's an agreement. Keep in mind this term is in bold and in red, so it's a definitional term. You'll want to be familiar with this term to at least be able to recognize it for quizzes and tests. So what are some things that can get involved or interfere with mutual assent? Well, one thing that can happen is that there can be hidden terms or hidden meanings. Imagine, for example, that Bob is negotiating with Larry, and Bob in his head says to himself, whenever I say the word blue, I really mean yellow. But he doesn't tell Larry that. And so he has this whole conversation about ordering shirts and pants and other kinds of things. And whenever he says blue, in Bob's head, he's thinking, I really mean yellow. And guess what Larry does? Larry thinks when Bob says blue, he means, blue, right? So Larry fulfills the order with the understanding that blue is what is intended. That would be an example, kind of a crazy one, but an example of mutual assent not being satisfied. Other situations can be when Bob is thinking to himself, I'm not going to tell Larry this, but I really want the shirts to have a pink stripe, over the belly button or whatever. He doesn't share that with Larry. I mean, Larry could have presumably made the shirts with a pink stripe approximately where the belly button would be, but Larry's not going to do that unless Bob tells him, hey, this is what I want on the shirts. And so this is an example of a hidden term. Bob wants something, but he's not telling Larry about it. That would be an example where we don't have mutual assent. Bob has a secret term that only he knows about. Larry thinks he's agreeing to the deal that Bob's presenting, but he's really not because he doesn't have all the information that he needs. In order to have mutual assent, it's important that all the parties to the contract be open and honest, and that they get the deal. They understand the ins and outs of the deal. And in fact, that is an important concept in contract law generally. A lot of law is adversarial in its nature. Certainly litigation is. I mean, in some sense, you can have just one winner. One party is going to persuade the court or the jury to award him or her whatever he or she is seeking. And if the plaintiff wins, by definition, it means the defendant loses. Or if the defendant wins, that means the plaintiff loses. But in the area of contract law, we like to think of this as being a win-win enterprise. Both parties are entering into this voluntarily with the hopes that it will render good things for him or her. Now, certainly there is some zero-sum nature of contract negotiations. For example, if Bob agrees to buy Larry's shirts for $10 a shirt, but Larry wanted $12 a shirt, well, either it's going to be $10 or $12, right? And certainly that's kind of a zero-sum game. However much Bob can avoid paying Larry is money that's in Bob's pocket. However much Bob has to pay Larry is money in Larry's pocket. But overall, they both see that they are both better off having entered into this agreement than if they had chosen not to enter into the agreement. Otherwise, why would they have signed the contract? So that is the idea. It's a little bit less adversarial. Now, obviously, if a contract becomes a subject of litigation, it becomes adversarial. But at least in the negotiation stage, usually parties see this as a win-win situation. There isn't, or there ideally shouldn't be, a lot of hostility, a lot of skepticism, a lot of distrust, although certainly it's important to have a healthy degree of understanding that your agenda does not completely line up with the other guy's agenda. So how do we determine whether mutual assent exists or not? We've seen this word several times already in this course, and we'll see it several times more. And if this isn't your first paralegal course, you've already seen this again and again, but I'm going to hit on this one more time. And that is the idea that we have an objective standard. What would that reasonable person think? What would that fly on the wall? What would that disinterested party who's neither a party to the contract or some other person who's going to benefit in some way because of the contract, what would he or she think was going on? Let's go back to the example of Bob. And whenever Bob says the word blue, he secretly means yellow. But he doesn't give Larry any indication about the secret meaning. Well, the fly on the wall would be seeing and hearing exactly what Larry hears. The fly on the wall would think, Bob wants some blue shirts. The fly on the wall would have no idea that Bob wants green shirts. So the objective interpretation of whether mutual assent exists would be, yes, it does exist. Bob says he wants blue shirts. Larry provides blue shirts. Looks like it's a good deal. What we're not going to do in litigation is read Bob's mind. We're not going to go in and say, well, gosh, but when Bob said blue, he really meant yellow. And even if Bob can show lots of documentation that he really, really intended to buy yellow shirts, maybe lots of emails, lots of communication with his staff beforehand about the big importance of getting yellow shirts or whatever the issue is. You know what? The courts really aren't that interested in that. What they're interested in is, what did Bob tell Larry? And if Bob really told Larry blue shirts, then the reasonable person who had been present would conclude that Bob, in fact, wanted blue shirts. Similarly with the pink line across the belly button. If Bob doesn't tell Larry that, even though Bob really, really wanted the pink line, that fly on the wall, that objective person, that reasonable person in Larry's situation would not have supplied shirts with pink lines. So again, we're looking at the objective standard. We're not looking at Bob's quirks and his own miscommunication and not understanding how English works, etc., etc. We're going to look at what a reasonable person would have thought was happening in this particular circumstance. We've seen this slide before, but we're going to see it again. When last time we saw it, we were talking about these two topics, offer and acceptance. But now we've moved a little bit farther down our slide, and now we're going to look at mutual assent. We're still looking at the overall topic of agreement. And as we know, agreement is our first element of a contract. Again, an element is something that has to be part of the deal, has to be happening in order for us to have a contract. If we don't have an agreement, we don't have a contract. We also need three other things. We need consideration, we need legal capacity, and we need legality. We're not going to talk about these today other than to point out that we need them. We also occasionally need writing, and we'll learn about that later on. But we don't call it an element because it's only a sometimes. These are every time we need these things. Now we have the element of agreement, which is a requirement for contract. But in order to have an agreement, we have, depending upon how you define it, 2 or 3 sub-elements. We need to have an offer in order to have an agreement. We need to have an acceptance in order to have an agreement. And many legal scholars think of as having a third item, which is mutual assent. We need to have mutual assent in order to have an agreement. Some scholars think of this as actually part of acceptance. And so they might see this as an element of acceptance. However you want to view this, any of those are fine ways of viewing it, but what we know is however you want to structure this, we need all 3 of these things in order to have an agreement. If we're missing an offer, we don't have an agreement. If we don't have an agreement, we don't have a contract. If we have an offer but we don't have any acceptance, then we don't have an agreement. If we don't have an agreement, we don't have a contract. If we have an offer and acceptance but we lack mutual assent, we don't have an agreement and therefore we don't have a contract. So this is our third part or third concept that we have in the umbrella of agreement. So let's go on to our next slide, which is our list of 6 things that can interfere with mutual assent. This is a pretty complete list. Sometimes legal scholars will group these a little bit differently, so this is not the only way of looking at this information, but I think it's a pretty straightforward and common way of looking at this information. So our 6 items are going to be fraud, misrepresentation, and mistake. All of these are kind of nicely grouped together because they all kind of have to do with the same concept. And then we're going to look at duress, undue influence, and unconscionability. These don't have as much in common, but there's some commonality here. We're going to be covering this during our first lecture, and we'll cover these other 3 topics during our second lecture. So let's get started on the first topic. This you will see in the Canvas module for this particular chapter. What I've done is I've transported it here. There's a lot of data to get on here, so I had to kind of simplify it a little bit. But you can see it's exactly what we were talking about. It's very much the same data that we have here with just a little bit more granularity. So we have, as our first element, we have agreement. We have as our second element, consideration. We have as our third element, legal capacity. And as our fourth element, we have legal object. I dropped off the legal writing because it's not a requirement. It's not truly an element. If we go back here and look at agreement more, we can see that we can add a lot more granularity. We know we need an offer in order to have an agreement, and we need an acceptance to have an agreement. Again, we can look at this as the third thing we need, mutuality of assent, or we can see it as a requirement of acceptance. Either way is fine. In Chapter 3, we talked about how offer has 3 sub-elements. The offer must have an objective intent to be an offer, or I guess the offeror, must have an objective intent to make an offer. And the offer itself must be definite and certain, must be a definite and certain proposal. And the offeror must communicate the offer to the offeree or offerees. Those are our 3 elements of offer. If we're missing any one of these, we don't have an offer, therefore we don't have an agreement, therefore we don't have a contract. Under acceptance, we also have, actually I have 4 things listed here, but we can see these track very closely. The first one, it basically means you can't have an acceptance if you don't have an offer. So if we don't have an offer, we can't have an acceptance. That's all I'm saying here. If any of these 3 elements are present, there's nothing that the offeree can do to fix it. The offeree could make his own offer, but then he's no longer the offeree, he's the offeror. And then the other ones track. Let's see. I guess here we have must be definite and certain. The acceptance must be directed to the offeror. And this is related to this one as well. And I guess you could say this is a little bit less tight, I guess, than I had in the slide before. So this may not be as good a representation as we had in the Chapter 3 slides. You might want to refer to that to get a little bit more precise apples to apples version of this. But the one that we're going to focus on in this chapter is going to be the stuff in red here. This is that mutuality of assent. You can see the same six things that we talked about in the last slide right here. We have here. So we're going to be focusing on these 3 during this lecture. Okay, so this is just another way of representing it. And this is available to you on Canvas. It has its own little icon in the module. So let's go forward. So we're going to focus on this first one, fraud. Fraud's an interesting thing. It's actually a tort as well as a basis for a breach of contract claim. or actually not so much a breach of contract. Well, it can be a breach of contract, but it can be a failure to create a contract. Because again, we're not really talking about breaching contract when we talk about these elements, because what we're saying is there is no contract. Something has gone awry here and the parties failed to make a contract. Well, you can't breach something that was never created. You can't destroy something that never existed. And so we usually don't call it a breach of contract. We maybe call it a failure of contract. And so we're going to talk about fraud from lots of different, in the program overall, we talk about fraud from lots of different perspectives, as a tort perspective, as a failure to make a contract perspective, and also as a breach of contract perspective. But right now we're looking at it as a failure to make a contract. Honestly, though, the definition of what fraud is doesn't really vary depending upon how we're using it. So let's consider the definition. What is fraud? It's deceit, deception, or trickery that is intended to induce and does induce another to part with anything of value or surrender some legal right. And we see we have 4 elements of fraud. Again, so this means we need to have all 4 of these to be present in order to have fraud. We might have something else wrong if we don't have all 4, but we probably can't call it fraud. So the first thing we need is we need that the fraudulent, the fraud, the person making the fraud, to have misstated a material fact, or possibly to have failed to state a material fact to the other party. Now we see this word material here. You won't see this in the textbook as a definitional term, but you are responsible for knowing it. And here is our definition. What is something that's material? It's critical to a party's decision to enter into the contract. So we're not talking about fabric here. We're talking about important. It's important. Imagine for a second that Bob Bob has a car. And it's a used car. He's had it for about 5 years. It's got about 70,000 miles on it, and he is planning on selling it to Larry. Larry's looked over the car, and Larry says, "Hey, Bob, do you know of any, imperfections to the car, any dings or things like that?" And Bob goes, "Nope, no, don't know of any." Well, it just so happens Bob did know that there is a small scratch on the underside of the car. You'd have to crawl underneath it to see it, and it doesn't pose any structural issues with the car, but it's not that attractive. So if somebody is underneath the car, they're going to think, that's not a very attractive scratch there. Bob knows about that problem, and he's given an opportunity to reveal it by Larry, because Larry point blank asks him, and Bob lies. So we do have a deceit, a deception, or trickery that is intended to induce and does induce another person, in this case Larry, to part with something of value or surrender some legal right. I mean, why else would Bob have lied? He is thinking, gosh, I don't want to say something that might cause this deal not to happen. I mean, I just want to be really safe here and just avoid anything that might cause the deal not to work out. And so let's say Larry drives the car away. 3 days later, he's inspecting the car underneath the belly of the car, and he sees a scratch. And he knows he hadn't done anything to cause it, so he knows it was there when Bob had sold the car to him. And so he thinks to himself, Bob knew about that, and I asked him point blank. Well, it is true that Bob perhaps his behavior probably did meet this definition of fraud, but I would argue that a small scratch on the underbelly of a used car that doesn't cause any structural issues is probably not material. It's hard to believe somebody buying a 5-year-old used car with 70,000 miles isn't going to expect that there's going to be some scratches. Especially on the underbelly, who really cares? And so I would say that it probably would not count as a material fact. Did Bob misstate a fact? Absolutely. But it's probably not a material fact under those circumstances. So we have to make sure that it's material. And usually we think about material as being something that a reasonable person, again, we're applying an objective standard here, that a reasonable person would have thought to himself, wow, that's a big deal. I'm going to have to really think about that before I go ahead and decide whether I want to buy this car or not. Something like what the odometer reading is. I mean, let me present another scenario. Let's say that Bob had the odometer wasn't working for about 30 miles. And so the odometer reads 70,100 miles, but it really should read 70,130 miles. Larry asks Bob, hey, is this odometer reading correct? And Bob says, yep, absolutely correct. He knows it's not. He knows it's 30 miles light. But really, is that going to make Larry not want to buy the car? I don't think so. But let's say that the odometer was turned off for 20,000 miles. So it says currently 70,100 miles, but it really should say 90,100 miles. Now I would say that's a difference that is looking pretty material. I could definitely see that Larry might say, oh, I don't want a car with 90,000 miles on it, or at least I want to pay less for such a car. That would be a material difference. So we have to make sure that the fact we're looking at is of sufficient significance that it could cause a person reasonably, objectively, to make a different choice. That's our first element as we're trying to prove fraud. The next is that the person making the statement has to know the statement was incorrect at the time he made it. So let's say Bob wasn't familiar with the fact that the odometer was turned off for some period of time. Maybe this was the car that his wife or his child routinely drove, and he just wasn't aware that there had been a period of time that the odometer had been turned off. Or maybe it was a previous owner who had had it off for a period of time. Well, then Bob can't be guilty of fraud. He has to know that the statement was fraudulent at the time that he made it, and he has to state it with the intent of deceiving, in this case, Larry. If either one of these things are not true, then Bob hasn't committed fraud. So he has to know it's an inaccurate statement, and he has to be saying this to Larry with the intent of deceiving him. Usually if you have this, you're going to have this, and vice versa. That's why it's one element here. The next part is that Larry has to believe Bob. Now let's present a different scenario. Let's say that when Larry is looking over the car, he can see that one whole side of the car is kind of crunched in. I mean, it's drivable, but the bodywork has clearly been dented and scraped, and it doesn't look the way that you would at all expect a car to look unless the car's been in an accident. And so Larry says to Bob, Bob, has this car ever been in an accident? And Bob goes, nope. I bought it from the dealer. It was brand new, and it's never been in any kind of accident. It's in mint condition. Well, Larry can look at it and know it's not in mint condition. This isn't subtle. These are significant dents over one whole side of the body. So while Bob is clearly making a misstatement of material fact, and he knows that it's untrue, and he's intending to deceive Larry, the problem that Larry is going to have if Larry does buy the car and tries to sue Bob over it is that Larry didn't believe Bob. Who would believe Bob under those circumstances? It's obvious this car has been in an accident. Let's imagine another scenario. Let's say that this car is, again, 5 years old. The tires are, have shown some significant wear and tear. There's other indications of some significant use of the car. And Larry gets behind the wheel. He looks at the odometer. The odometer says 200 miles. Larry says, hey, Bob, is this odometer reading correct? Bob sticks his head in, yep, only driven at 200 miles. Not a big one for driving the car. I've had it for 5 years. I take it out maybe, once a month, drive it around the block, and put it back in the garage. Really? Is that true? Because why are the tires so bare at this point? Bob might be lying. He might well know that he's lying. He might be lying to deceive, but it's not very reasonable for Larry to believe that. So we have to satisfy number 3 as well. And finally, the fraud has to cause Larry, in this case, some type of damage. Let's go back to the example of the car that had the odometer turned off for 20 miles. And so 30 miles. So instead of it reading, the odometer reads 70,100 miles, when it should read 70,130 miles. Let's assume, for the sake of argument, that that really is a material fact. And let's also assume that Bob knew about the fact that the odometer had been turned off for a period of time and that he wanted to trick Larry. Let's also assume, which this was probably pretty reasonable, is that Larry really was tricked. He really did believe the odometer was correct. Well, what harm did Larry have? I mean, unless there was some kind of warranty that expired at 70,100 miles or something. It's hard to believe that 30 more miles of wear and tear on a car that has over 70,000 miles is going to be significant in terms of the value of the car. So I would say having 30 more miles in the car hasn't really caused Larry any measurable damage. So there's no damages, and so therefore Larry isn't going to be able to successfully sue. So the bottom line is you need to have all four of these. These are the elements of fraud, just like we've covered the elements of contract. If any of these are missing, we may have something that Larry can pursue, but we're not going to call it fraud. So what happens? Let's assume that we can prove all four of those elements. We're Larry, and we can prove all four of those elements. Well, one thing that we can have, what we can do is we can make the contract voidable. So Larry can basically say, I want takebacks. I want all of my money refunded, and I will surrender the car to Bob, and we'll go about our business as if this transaction had never, ever happened. Because in a way, it never did happen, because there was no agreement, because there was a lack of mutual assent. If you're lacking mutual assent, you don't have an agreement. If you don't have an agreement, you don't have a contract. If you don't have a contract, why is Larry driving around Bob's car, and why does Bob have Larry's money? Doesn't make any sense. Sometimes, though, instead of voiding the contract, the Larry might say, you know what, I really do want to keep the car. I mean, even though it's not what I wanted, I have it now. It's just more convenient. I don't want to rescind the contract or cancel the contract. I want monetary damages. I want to get some kind of refund of the purchase price. When we use the word voidable, we mean it can be voided, but not necessarily that it will be voided by the party who's been injured. In our situation, Larry. Larry gets to pick. He can pick to void the contract. He can pick to rescind it. Or he can say, no, you know what? The better solution for me is money. So what is the goal of whichever choice Larry makes? The goal is to put the parties back in the position they would have been in if they hadn't entered the fraudulent contract. Obviously, the main focus is on Larry, putting him back in the position that he would have been in if he hadn't been tricked by Bob. So that's our discussion of fraud. Now we're going to move on to misrepresentation. One of the most important things when we talk about misrepresentation is to contrast it with fraud, because it's very similar to fraud, but there's one big difference that's important to keep track of. So this is our definition of misrepresentation. What is misrepresentation? Again, this term is in red and in bold, so you'll want to know the definition. And I think I've added this part to the definition, so be on the lookout for this. The textbook definition isn't as complete as the one that I'm providing here. So a misrepresentation is a misstatement of fact designed to lead one to believe that something is other than it is. It's a false statement of fact designed to deceive. Let's contrast that, though, with our definition of fraud. Okay, so we could say that this is a misstatement of fact right here, deceit, deception, or trickery. That's kind of like a misrepresentation of fact, right? So that tracks. And now we have designed to lead one to believe that something is other than it is. That is intended to induce and does induce another party to part with something of value to surrender some legal right. So you can see that the definition of misrepresentation and fraud track very closely. And that's why I added this part, because the definition provided for the textbook doesn't make it clear that this misstatement of fact is in some sense innocent. The person saying it in this case, we'll say Bob, didn't know he was telling a lie. He thought that what he was saying was true. So the difference that we're going to focus on between fraud and misrepresentation is the intent of the misstater, is the intent of Bob. What was he trying to accomplish? Was he trying to make this person believe something that wasn't true or not? Because we don't, another term that we'll see for this sometimes is scienter. Knowledge that something is not correct. But we don't have to have this in this situation. Okay, let me tell you a story. When I was a youngster growing up, my mother who worked full-time, uh, was the person who did the laundry in the household. And my father, this is back in the days when men wore suits to work every day, and my father didn't like to get his shirts pressed at a dry cleaner's place because they weren't as soft as he liked, and they weren't the shirts weren't as crisp as he liked them. And so my mother washed his shirts and ironed each one every week. So she would do, I guess, 6 shirts a week, and so they would all be nice and beautiful. And it wasn't a hugely long undertaking, but it probably took her an hour to do a week. And so obviously it was really important that as soon as the dryer was done drying, that she get those shirts out of the dryer, hang them up promptly so that there would be as few wrinkles needing to be ironed out as possible. And that was true for the rest of the clothes. Again, she didn't want to spend any extra time doing it. But because she worked full-time and my dad worked full-time, laundry was kind of a tricky thing to do because, by the time you got home from work and you ate, there wasn't a lot of time to start a load, to put it in, to wash in the washing machine, to put in the dryer, to take the clothes out. That was kind of a tricky thing, and the weekends were full of various activities, and so there was always this concern of, well, am I going to be around when the dryer stops drying? Well, this was, as you perhaps can gather, kind of an issue in my family. Are we going to be there at the right time? And so it was about this time, sometime I guess in the 80s, where a new feature on dryers became common. And this was a feature wherein the dryer would complete its drying and it would stop, but then it would restart about every 5 minutes and tumble for just a little bit. And the idea here was that the clothes wouldn't get wrinkled because they were being moved around a little bit. And so as a result, you didn't have to be right at the dryer when the dryer buzzed that the clothes were dry. You might have even an hour or two of leeway. So if you're out at dinner or at the movies or at church or wherever, you didn't have to rush back. You could have some leeway with it. Well, my mother saw this being advertised, and she was persuaded that this was a complete game changer. This was going to add tremendous quality to her life. She was thrilled about this, and we were all thrilled that Mother was thrilled about it. So we decided to go down and buy a washer and dryer together, and we bought them in tandem. My parents were Kenmore fans, and so we went to the Sears and shopped for some Kenmore washers and dryers. My parents are very frugal people. They're not ones to buy appliances unless they need it. Historically, things broke before they would buy them. But this was something that was just so thrilling that they decided to go out and buy it even though they didn't technically need them. So they arrive at the Kenmore, and there's a salesman there. He's kind of young. I think he might have even told my parents he was pretty new to the department. We'll call him Bobby just for fun. Anyway, Bobby is kind of assigned to be their salesman, and I think I'm tagging along too. So they are checking out the washers and the dryers, and my mom says, listen, Bobby, what we're really here about is getting one of those newfangled dryers that will restart every 5 minutes once it's dried. And Bobby isn't surprised at this because this is a really cool feature. Lots of people are buying dryers just for this purpose. And so my mom says, show me which dryers have this feature, because we don't want to waste our time looking at the old dryers, because we know if we're going to stick with the old style, we're happy with the dryer we have now. So Bobby points at the ones that have this new feature. And they're all kind of expensive except for one. And this one is significantly less expensive. So my mother says, well, Bobby, why is that machine so much less money than this machine? And Bobby said, listen, this is for last year's model. We want to get it out of our warehouses, and so we're offering a good price on it. But really, it's just the same thing as these others. And who cares about having the latest and greatest model of dryers? And so my parents talk it over. They confirm that yes, in fact, this dryer does have the feature. Bobby assures them that it does, and they buy the washer and dryer pair, this less expensive one that does have the feature. We sign the paperwork, we go home. A few days later, the dryer arrives. It's installed. The delivery men carry off the old washer and dryer, and they plug everything in and do all the installation work. And then my mom puts in, she actually takes a load of towels and she dampens them a little bit and she puts them in the dryer and she hits the button and she starts the dryer. And I think it's about dinner time. We have dinner, and maybe even during dinner, the dryer goes off. And so we think, this is the moment. So we go to the laundry room and we open the door, and we can see that the dryer stopped. And so we look at our watches. Okay, in about 5 minutes, it'll be starting up. 1 minute passes. 2 minutes pass. 3 minutes pass. 4 minutes pass. 5 minutes pass. 6 minutes pass. It's not restarting. Well, maybe it starts every 10 minutes, Mother says. Okay, so we keep on waiting, but you know what? 10 minutes comes. It doesn't restart. So now my mother's grabbing the manual. Well, I must not have hit the right button, or there must be something I didn't do right. So she's flipping through it, but she can't see that section. But I mean, it's written in a very difficult to understand lingo, and so she's sure it's there. She's just not seeing it. But she does quickly find a 1-800 number. So she grabs her phone, landline, of course, and calls up the 1-800 number. And she says, can you please help me? I'm sure I'm just not hitting the right button in the right order, whatever. And so the customer service person asks some questions. Well, what's the model number? What's the this and the serial number? And so Mother has all that document right there. She pulls it up and she relays that. And the customer service representative says, "Ma'am, I'm very sorry, but your dryer doesn't do that. It won't restart. When it's done, it's done. I mean, you can manually restart it every 5 minutes if you want, but it's not going to do that automatically." So my mother, as you can imagine, was pretty devastated. She was not happy, but she says, "Well, thank you," and she hangs up. And so we had the dryer that didn't restart. Very sad story. So the question is, did Bobby commit fraud, or did he engage in misrepresentation? Now, of course, we don't know which it is. My parents didn't pursue it any further than that. They just made do with the dryer they never needed, that didn't have the features they wanted. And it's possible that, honestly, Bobby thought that the dryer that he was selling them actually did have a feature. After all, he was a new employee. Maybe he just got confused, and he really wanted to get them the dryer that they wanted, but he made a mistake. If that's the case, then this is a case of misrepresentation. He made a misstatement of fact, and he stated that fact because he wanted my parents to believe something that was true about that fact, but in fact, he was wrong about that fact. But he honestly believed it. That would be an example of misrepresentation. But there's also the possibility, I hate to impugn Bobby's character, but there's also the possibility that Bobby knew that this dryer that he was selling to my parents was not going to restart. Maybe his boss had told him, "Listen, Bobby, we got to unload these loser dryers that nobody wants. Do whatever you have to get these sold and get them off of our sales floor." And so Bobby might have intentionally lied. He might have known. He certainly knew as a material fact, because my parents made that very clear. He certainly, if he knew it was he misstated the fact, and he knew that it was a misstatement. And certainly my parents relied upon that, and certainly caused my parents damage, having a dryer that isn't what they wanted. We don't know. It could have gone either way, because my parents didn't pursue it any further. But you can see how, from the perspective of the innocent person, in a way, you don't really care. You're as inconvenienced by misrepresentation as you are by fraud, even though there's, I guess, maybe less evilness involved in misrepresentation than there would be with fraud. You can see how it's easier to prove misrepresentation. If my parents had chosen to pursue a claim against Bobby and Sears, they probably would have alleged both fraud and misrepresentation. They might not have won the fraud, though, because Bobby might have gone out there and said, I thought that it was going to restart. I was wrong, but I thought it was. And therefore, my parents would have instead proved misrepresentation. But either way, you'd allege both, but you'd be able to prove misrepresentation a little bit easier. And I like to think about this as the cross finger scenario. It's when, let's imagine Bobby, he wasn't wearing a suit, but let's imagine Bobby had been not sure whether this particular dryer was going to restart or not. He thought it was, but you know what? He wasn't really that sure. He should have checked. He should have gone to the manual. He should have called aside another salesperson or called up his boss or something. But he thought, I'm just going to wing it. I want to make this sale. I think it is. And I'm just going to cross my fingers and hope that it's going to be okay. There is with respect to misrepresentation, there is a duty to disclose facts that affect some basic assumptions underlying the contract. So let's imagine that as Bobby is helping my parents never actually ask Bobby, does this dryer actually restart? But as he's helping my parents, he's hearing them talk between themselves. Yeah, the dryer we need, we really want it to restart. That's really why we're here. We already have a good dryer. We don't need another dryer, but that's what we need. But they never actually ask Bobby a question. So he never actually is put in the spot of saying one way or the other. But he knew what they wanted. So the fact that he doesn't clarify their misunderstanding about the dryer when he knows that it is important, even that can qualify as misrepresentation. Let's assume that my parents assumed incorrectly that all dryers nowadays have this newfangled feature. And so they don't even bother to ask Bobby about it. But Bobby's there hearing them talk, and he knows very well that the dryer they're attracted to doesn't have that feature. He has the duty to disclose that. Now, you may have heard the term caveat emptor. This is a Latin expression that means let the buyer beware. It's common to have people say this, and it's certainly probably a good idea in life to be a little cautious, a little suspicious, a little skeptical. But really, in the law, the seller or can't really rely upon caveat emptor as a way out of transactions because, again, of this misrepresentation idea. Bobby can't say, well, you know what? That couple should have read the manual before they bought, because if they had read the manual, they would have seen there's no mention in there about any restarting after the clothes are dry. So it's really their failure to be careful. No, the court system would say, if you misrepresented or you knew that they thought this was important and you chose not to clarify for them, the doctrine of caveat emptor is not going to save Sears or Bobby. That is no longer the usual legal standard that we have today. Let's consider the issue of exculpatory clauses in contracts. Let's first of all break up the word exculpatory. For those of y'all who are Roman Catholic, you may be familiar with the term mea culpa, which is something that traditionally was said when people made confessions. And this means my fault, mea culpa. And we hear this, people say this, even people who aren't Catholic will say this from time to time to make an apology, mea culpa. That was my mea culpa. That was my fault. It's a Latin expression. And you can see in the expression mea culpa that we have part of the exculpatory clause. You can see we have culp right here. So this means fault. And the atori here is just making it into an adjective. It's an adjective ending. And then the ex means out of in Latin. We see that extemporaneous, for example, exempt, those words mean out of. So we're saying out of fault clause. So this is a clause in a contract that excuses or removes fault from one party for his or her wrongful actions. So you can imagine a contract. I mean, my parents didn't really enter into a contract in a written format. There was a sales receipt, but there was no lengthy contract when my parents bought the dryer from Sears. But let's imagine there had been. There might have been a clause in that contract that said that my parents will hold Sears harmless for any misrepresentations that occurred during the sales process. Well, that would be an example of an exculpatory clause that's saying even if one of the parties to the contract messes up, the other party can't get any damages because of the mess up or is restricted to a certain level of damages. These types of clauses are not uncommon, but they are things that courts do not look upon favorably. Courts don't like anyone kind of getting a get out of jail free card. If you made a mistake, you ought to be held accountable for that. You ought to be able to be sued for it. And so courts usually interpret those as narrowly as possible, and we'll see later in our next lecture a discussion about how they can be unconscionable. So while you shouldn't work under the assumption that an exculpatory clause is never enforceable, on the other hand, you shouldn't count on an exculpatory clause kind of excusing your bad behavior, even if you have an exculpatory clause in your contract. Okay, so let's look at a special category of misrepresentations, and that is when we have a fiduciary involved. Now, not all misrepresentation situations involve a fiduciary. For example, Bobby wasn't a fiduciary of my parents at all, and yet my parents could still advance a misrepresentation claim. But it's a fairly common situation that you have a fiduciary and a misrepresentation claim. And this is when the defendant is the fiduciary of the plaintiff. What is a fiduciary? This is, and here we have the definition, a person in a position of trust. And we say that a fiduciary owes a duty of utmost good faith and loyalty to the person that he is the fiduciary for. And as you can see, this term is in red and bold, so you want to have this committed to memory. And here's a definition of fiduciary relationship. Again, this relationship involves having a fiduciary, obviously. It is a relationship between two persons in which one is obligated to act, the one here is the fiduciary, to act with the utmost good faith, honesty, and loyalty on behalf of the other. This is a very high obligation. And we see this with respect to partners. So if I enter into a business with you, let's say we open up a taco shop, I am your fiduciary and you're my fiduciary. So I can't secretly sell tacos in the shop to people without running it through the cash register and just taking those profits for myself. I would be breaching my fiduciary duty under those circumstances to my partner. So sometimes it's mutual. Both partners would be fiduciaries, but sometimes it's just a one-way thing. An attorney is the fiduciary of the client, but the client is not a fiduciary of the attorney. Trustees are the fiduciary of the beneficiaries to the trust, but beneficiaries are not fiduciaries of the trustees. So it can go both ways. So you can see if somebody is a fiduciary and that party commits misrepresentation, he makes a misstatement of fact designed to lead the other party to believe that something is other than it is, you can see how that can be a situation of misrepresentation. That's pretty significant. But whether you have that fiduciary situation or not, if you are in a circumstance of misrepresentation, you get the same things that you get with fraud. Let's go back and look at this. We see that you can get for misrepresentation money or rescission, which is, again, just basically cancellation of the contract. What do we get for fraud? Money damages or rescission. Same thing, right? So you might be thinking to yourself, well, gosh, it's harder to prove fraud and you don't get any more for fraud, so why would you ever bother suing about fraud? There are some strategic reasons why a suit for fraud can make sense even when you can prove misrepresentation, because even though in order to prove up a contract, you're not going to get more or less just because you've proved that scienter, that evil mind, you are usually going to be alleging, if you're the plaintiff, some type of tort theory as well. Well, when you can successfully allege a fraud tort, you are going to find yourself more damages are going to be available to you. So while right now under this particular scenario, the formation of the contract part of proving up a misrepresentation or fraud doesn't really make a difference. It still can be significant in other contexts. And so we have here, again, the same goal that we saw with fraud, and the goal is to put the parties in the same position they would have been in if they hadn't ever entered into the misrepresented contract. Okay, so we've talked about our first two of our ways of destroying mutual assent, fraud and misrepresentation. And now we're going to talk about our third one, which is mistake. What is a mistake? Well, it's an error, a misunderstanding, an inaccuracy in contract formation. I mean, basically it's what you think it is. There's nothing particularly clever about this legal definition. You can see it's in red and in bold, so you want to be sure to have that committed to memory. So a mistake occurs when the parties are wrong about some act or event that is, and we still need that material requirement, material to the transaction. One thing to keep in mind is that ignorance of the law is never a basis for a successful mistake claim. So we're not talking about not knowing how the law works, we're talking about some fact about that particular transaction. So an example of a mistake could be, if you had this problem, 2 + 2 = 5. Guess what? That's a mistake. We all know it should be 4. This mathematical error would count as a mistake. So now there are two categories of mistakes that we're going to look at. One is mutual mistake and the other is unilateral mistake. So what is mutual mistake, or I guess you could call it bilateral mistake? Well, again, it's probably what you think it is. Just like we had mutual assent, that means both parties are doing it. Mutual mistake means both parties are mistaken. And here again, this is the definition. This is a term in red and in bold, so we want to be sure to commit this to memory. A misconception of both parties to the contract, each laboring under the same set of facts with respect to a material fact justifying reformation of the contract or rescission. Now, this is a little bit misleading. I didn't actually change this definition, but I don't love it. It doesn't have to be, we'll say that it's Bob and Larry. It doesn't have to be that Bob and Larry have the same misunderstanding. They might have different misunderstandings. Let's say there's Bob's view of the world, Larry's view of the world, and there's the right view of the world, the one that's actually correct. Now, Bob's view may not be the same as Larry's, and Larry's view may not be the same as Bob's. But let's assume Bob's view is different than the right view, and Larry's view is different than the right view. There we have mutual mistake. So in a mutual mistake case, both parties are wrong, but they don't have to agree about the mistake. Bob may be thinking green, and Larry's thinking pink, and the right answer is purple, for example. Let's talk about a particular category. And this one's a little tricky to get one's head around, so let's take a little bit of time talking about this one. Sometimes when people enter into a contract, well, very commonly when people enter into a contract, they are considering how to manage the risk. You know, there's always risk with the future. I mean, if I'm buying a car from you, maybe the transmission will go out the day after I buy it, or maybe it will be discovered that the airbags are faulty, that there will be a nationwide recall of the airbags the day following. Life is uncertain. Lots of things can happen that you and I can't anticipate. We may know there are possibilities, but we don't know it's actually going to happen. And so one thing that people do in contracts is they try to manage that risk. So it might be that, again, we'll go back to Bob and Larry. It might be that Bob says, hey, Bob says, hey, Larry, if you'll take the risk of X happening, I'll pay you a little bit more money. And so the way Bob's managing the risk is almost like he's buying insurance from Larry. And so this way Bob can sleep at night. He knows that if X happens, it's Larry's problem. And of course, Larry is only going to agree to assume that risk if Larry is going to get something out of it, maybe a little bit more money, for example. So you can see how the parties might contract to this. And one way that the parties can contract to manage the risk is they can actually say in the contract, hey, you know what? If we have some kind of mutual mistake going on, it's all going to be on Larry, or it's all going to be on Bob, or however the risk is going to be shared. Somehow or another, we messed up. We've decided who's going to bear that risk. And so if we decide in the contract Larry's going to bear the risk, guess what? Larry can't sue when it ends up that there is mutual mistake. Bob can, but Larry can't. And so you have to be sure that you aren't the person who's negotiated the right to object to a mutual mistakes type situation. This isn't in your everyday contract, but you can imagine a more sophisticated transaction, you might well want to do this, especially one with kind of lots of risk and lots of moving pieces. So how do you solve this problem? Let's assume that we don't have this type of provision in the contract. And so there's been this mutual mistake. Bob is suing. What is he suing for? Well, he's likely that he's going to sue for rescission. We've already talked about rescission. Rescission is just cancellation of the contract. And you know what? That makes sense because after all, the mutual assent is an element of an agreement. So if we are lacking mutual assent, and we would lack it if we had mutual mistake, then we are lacking an agreement, and if we're lacking agreement, we're lacking a contract. So when we say we rescinded, in fact, what we're really saying is we never had a contract to begin with, so there's nothing really to rescind. We're just acknowledging the fact that nothing ever really existed. And so that's a common solution and a kind of the expected outcome in a mutual mistake scenario. There is a big case in this area. Talk about it, and I have a lot of information on Canvas about it, so please spend a little bit of time looking over the material that I've posted on Canvas. This case is oftentimes called the Peerless case. The Raffles v. Rickles case is also the name for it. And this is a case that developed in the late 1800s in England. Before I go into it any farther, though, let me pause and talk a little bit about the common law. You may think when you hear the date of the case, you may think to yourself, well, gosh, why do we care about this? I mean, at the time that this case was decided, America had been its own country for over 80 years. Well past the time that Great Britain had any say-so in how we ordered our affairs. So who cares what cases were being decided in England in the 1860s? It certainly didn't apply to us. Well, in some sense, that's true. I mean, certainly we were an independent country and had been an independent country for a long time. But the idea of the common law still applies to this day. There can be a decision made in an English court tomorrow. And if courts in the United States look at it and go, yeah, that's smart, that's a good idea, there's nothing in the world to stop our courts from adopting the decision. Now, do they have to? Absolutely not. It would be a persuasive authority, not a mandatory authority. But that can and does happen from time to time. It's more likely to happen, frankly, within the United States. It's more likely, for example, that a Texas court would adopt the opinion of a Oklahoma court or a Massachusetts court or a Florida court than an English court, simply because geography and culture and things along those lines. But it absolutely can happen across country borders, and it has in this case. The doctrine that we'll see in the Peerless case is a doctrine that we routinely see talked about in the United States. The other interesting thing about this case is that if you know people who have attended law school, have completed their first year of law school, they will know about this case because this is a very, very common case that first year law students will read about and know about, the Peerless case. So let me tell you a little bit about what happened, and I apologize, I can't remember which one of the two parties are which, but I'm going to say that Raffles is the man who owns a garment factory, and Rickles is the person who sells cotton coming off of boats. So let's pause and talk a little bit about how the Industrial Revolution, at least in the garment making industry, was happening. Back in the 1860s, cotton was being grown in India, and then it would be shipped, obviously in boats, to England, and then there were these factories where the cotton would be made into cloth so that they could be made into dresses and clothes and other items along those lines. Well, Mr. Raffles owned a factory that would take the raw cotton and make it into fabric. Obviously, he needed the raw cotton in order for his factory to generate its output. And so he would go periodically down to London and negotiate with cotton merchants, I guess, to get this raw material that he needed. So he went to Mr. Rickles' house, and I guess the way they did it is that Mr. Rickles' would say have a contract to sell the cotton on certain boats. And what would happen is that the uh, uh, garment factory owner would actually buy the cotton balls on a particular ship sight unseen. So let's say that a ship was leaving Bombay, India on, we'll say September 1st. And let's say that ship would be filled to the rafters with cotton, and then when it would arrive in London, it would be loaded off the ship and given over to the factory maker or factory owner, and then he would pay for the cotton. But let's imagine a different scenario. Let's say that the ship sank. Well, the factory owner was going to bear the risk of that happening, and so he would still have to pay, even though he's not getting any cotton out of the deal. He was bearing the risk of there being some kind of typhoon or storm that causes the ship to sink. Or let's say that, the ship was about to sink, so they had to toss the cotton overboard. This cotton's pretty light, so I don't know if that'd be an issue, but let's assume something happened or it got soaked with salt water and was unusable at that point. Anyway, whatever happened, he's going to be responsible for the price, whether or not he actually gets the cotton. Okay, so Mr. Raffles enters into a contract with Mr. Rickles to own the cotton that would be arriving on the Peerless boat. They sign it, they seal it, they have the deal, they go about their business, they both feel that this is a win-win. Raffles is going to get the cotton he needs for his factory to make progress, and Rickles representing the, I don't know if he represents the cotton plantations in India or if he represents the actual ship, but whomever he represents, he's making a nice profit, his client's making a nice profit, everybody's getting a win out of the situation. So fast forward to October, and Mr. Raffles shows up at Mr. Rickles' business and goes, okay, Mr. Rickles', I'm here to pick up my cotton. Where do I need to go? I've got my transportation wagons ready to take the cotton. And Mr. Rickles' is like, what do you mean? I don't understand. He goes, well, as you know, I ordered and purchased the cotton for the Peerless. The Peerless arrived yesterday. I can see it in the harbor right now. And so I want to go ahead and pick up that cotton and go about my business. So how do we do that? And Mr. Rickles' goes, I don't know what you're talking about, but the Peerless doesn't arrive until December. There's no way it could be here yet. Boats can arrive late, but they almost never arrive early, and they're certainly not going to arrive 2 months early. That cotton hasn't even left India at this point. So I don't know what you're talking about, but you're not talking about the boat with your cotton on it. Well, Mr. Raffles goes, but look down there. You see that boat? That's called the Peerless. And so they start researching it, and lo and behold, they realize after some research that their contract specifies the Peerless, but the men were talking about 2 different Peerless boats. Weirdly, there are 2 boats that transverse between Bombay, India, and London at this time carrying cotton. And one Peerless was supposed to arrive in October, and one Peerless was supposed to arrive in December. Well, Rickles had a contract for the December Peerless boat to sell that cotton. Raffles thought the contract was for the October Peerless. And so the contract that they wrote doesn't specify any of this. They were both assuming that the other person knew which boat they were talking about. Here is a picture of the December Peerless. We don't have a picture of the October Peerless, but my guess is it looks very similar. That's how famous the case is. People painted paintings about it. So this went into a litigation because Mr. Raffles said, I want my money refunded. And Mr. Rickles', I need cotton now. I don't need cotton in 2 months. My looms are going to be empty. I'm going to lose money. My workers are going to be, starving to death because there's no work for them. Well, in this case, it went into litigation, and basically what Mr. Raffles wanted was to rescind the contract, was to get back the money he had prepaid, if there was any, or at least not to be required to pay any future monies. And he would have no obligation for this December peerless transaction, nor would he be eligible to get any cotton from the December peerless. And so the first thing the court did was they tried to look at the contract. I mean, was there a way of reading it that would reveal which boat was meant, the October peerless or the December peerless? They read it, but they couldn't make any judgment about which one of the boats the parties had actually meant to enter into. And so the court concluded this was a case of mutual mistake. And the court said, as a result, there was no contract because there was no true mutual assent. There was no meeting of the minds. So therefore, the factory owner can rescind the contract, get a refund of all the money that he paid, and he has no entitlement to the cotton because of the idea of mutual mistake. So this is an important case. You do need to know the name Raffles v. Rickleshouse. You do need to know the name Peerless, and you need to know that it relates to mutual mistake. And you need to know that in a mutual mistake, yes, you are going to get rescission. You're not going to get monetary damages, though, because it wasn't like the court blamed the cotton merchant. Hey, you should have made it clear. No, he's saying you were both mistaken because you both had a different understanding. So we're going to rescind the contract, but we're not blaming anybody under these circumstances. So that's how mutual mistake works. Let's talk about unilateral mistake. Unilateral mistake, of course, is whenever you see the word unilateral, think about unicycle, one-sided mistake. That's what lateral means, side. One-sided mistake, meaning one party is mistaken, but not both. Again, this term is in red and bold, so it is a vocabulary term that you need to be familiar with. So a unilateral mistake is a misconception by one party, but not both parties, to a contract with respect to the terms of the contract. Even when the mistake is about a material fact, the courts are likely to enforce the contract when there's just one party who's mistaken. The idea here is, well, gosh, you should have been more careful. I mean, you know, if Bob was correct and Larry just had this silly idea that the facts were different, well, Larry should have asked more questions, should have researched more to get the facts straight. For example, let's go back to our peerless case. Let's say the contract had actually specified December peerless in the actual body of the contract, and Raffles just hadn't been paying that good of attention. He was so persuaded that it was going to be the October peerless, he just kind of signed away and didn't read it carefully. Well, then we'd have a case of unilateral mistake, and the courts would have been much less interested in letting Mr. Raffles out of the contract. They would have said, no, you messed up. You're a grown up. You need to read the stuff that you're writing. You need to ask smart questions. It's not the other guy's fault that you were mistaken, and so therefore we're not going to rescind the contract under the circumstances. But there are a few situations where even when you have a unilateral mistake, the courts might give some love to the mistaken person. First of all, it can be that the mistake creates such a profound unfairness to the party who made the mistake that it now becomes unconscionable to enforce the contract. Unconscionability is our sixth item of that destroys mutual assent. So we'll talk more about the concept of unconscionability later on. But there can be times where a unilateral mistake makes the overall contract unconscionable. The next category would be is when the person who wasn't mistaken had reason to know that the other party was confused. So let's go back, let's go to our mythical case where the contract actually specifies the December peerless, but Rickleshouse knows or suspects that Raffles is still thinking that it's going to be the October peerless where his contract is, where his cotton is going to arrive. All he had to do was just take a second and say, hey, Mr. Raffles, you do understand that I'm selling you cotton on the December peerless, which is going to arrive in, December. You just want to make sure you understand that. Those few sentences could have saved the other guy from having this very mistaken impression. And so under those circumstances, when one party knows about the other party's likely mistake and could have easily solved it, the court's going to be like, hey, why didn't you help out? why didn't you help out the other guy? I mean, that's just the decent thing to do. And so if the non-erring party had reason to know the mistake, he ought to have clarified it. The other time, a sentence that the non-erring party could have caused the mistake, the misunderstanding. And that probably gets pretty close to a fraud or a misrepresentation situation, but maybe not all the way to there. Let's say that Mr. Rickleshouse actually knew about both of the peerless boats, and maybe he actually sold cotton for both of the peerless boats, and maybe early in the conversation he talked about selling the cotton from the October peerless boat to to Raffles. But as the negotiations progressed, then they started talking about the other peerless boat. And so he should have made it really super clear under those circumstances that we were switching from one to the other. But in some sense, it was Rickleshouse's talking about the October peerless that caused that idea to stick in Raffles' mind, even when they switched over to the other peerless boat. So he might have innocently caused the miscommunication, but under those circumstances, the court might say, we're just not going to enforce the contract. We're going to allow that solution of rescission in these cases. These are the exceptions. This is the unusual situation. Most of the time, it will be enforced. So these are just kind of the weird circumstances. So let's compare our types of mistakes. So we have mutual mistake here, and we have unilateral mistake. The first difference is in a mutual mistake, both parties are wrong. They can be wrong in the same way or wrong in different ways. Unilateral mistake, only one party is mistaken. In mutual mistake, you're going to have the remedy of rescission or cancellation of the contract. Under unilateral mistake, there's no remedy. The contract is going to stay in effect. The one time that you can't use rescission is, again, when there's been a negotiation and the plaintiff has agreed to bear the risk of the mistake in the terms of the contract. So that's when you don't get rescission. When in a unilateral situation, you can possibly get rescission, again, in these three situations which we just talked about. Now the contract is unconscionable, or the non-claiming party had reason to know of the claiming party's mistake, or the non-claiming party perhaps caused the suing party to make the mistake. So this is kind of a good summary of the distinctions between the two, unilateral and mutual mistake. Big important difference. So you don't want to be Homer, you don't want to make the mistake in your contract. And that's one of the reasons it's so important to be really, really careful when you're drafting contracts, when you're negotiating contracts, that you're dotting every I, crossing every T, considering every possibility. We have now completed our first three elements of things that can destroy mutual assent. We've talked about fraud, misrepresentation, and mistake. And you can see in these three categories, they all have something in common. Somebody thinks something is true that's not true. And these are the three ways that they can present themselves. In the next three, we aren't going to have that situation. We have another issue, not of somebody believing something that isn't true. Let me just, before we conclude, flip to the end, and we're going to look at where we are here. So we have now covered the first half of our mutual assent situations. We need to have mutual assent. If we're missing mutual assent, either because of fraud, or because of misrepresentation, or because of a lack of mutual assent, then we're missing one of the elements that we need for agreement. Therefore, we don't have an agreement. If we don't have an agreement, we're missing that element, and therefore we don't have a contract. So it's a really important thing that we have all those elements. If you have any questions about this material, as always, feel free to drop me an email or give me a call during my office hours, or come by my office hours. I'll be glad to talk about these issues in more detail and fill any blanks to help it make more sense to you. I thank you for your attention today, and I hope you have a wonderful time. Be sure to watch the second video to learn about the other three types of mutual assent destroyers.